Okay. Folks, I think we're going to start now. I want to welcome all of you to our annual Edward Spare Public Interest Law Fellowship program. It is wonderful to be able to be here in person. We have not been in person for this program or, for so many programs, obviously, since here. Our last program in person was in March 2019. I'm Professor Liz Schneider, and I'm the founding director of the Edward V. Spare Public Interest Fellowship Program, founded in 1985, which with hundreds and hundreds of Spare fellows who have been committed to public interest work while they were here at Brooklyn Law School, and so many have continued on doing that work in many, many, many contexts. I am really delighted to be here with many current fellows, with many Spare alums that I've just seen. It is fantastic to be able to see people in person, and our members of our faculty and our new director, Professor Cynthia Gazzo, who's going to be speaking at the end of the program. We have a great program tonight. As with so many Spare forums before, on incredibly important and cutting-edge topics. And this program on the dangers of surveillance technology is exactly fitting to be one of these programs. Thanks to all of you. This is a program that many, many people played a role in developing, in addition to the Spare program, the National Lawyers Guild here at the law school, the Legal Hackers, and the ACLU, the Brooklyn Law School ACLU. And so we're very, very happy that we were able to collaborate with many other student organizations to do this program. So I'm now going to turn the mic, or release the mic, as it were, to Professor Susan Herman, who is one of the co-moderators for the program today. You can see that on the program that was on your seat. I hope and I'm sure that this will be an incredibly stimulating and important program, and will continue the legacy of annual fora in the past. So thank you all again for being here, and let's go do it.
Good evening. By way of background, I want to say that this issue of who's going to watch the watchers is nothing new. One of the principal causes of the American Revolution was that the colonists rather vehemently objected to government surveillance. They complained about general warrants being used for the government agents, the king's agents, to be... Is this not working?
Well, it's working, but you have to speak more slowly, really loud.
So how about this? If I get really close to it, is that no? I think they have to. It's all about technology. It's not actually about surveillance at all, right? Okay, so trying again. Is this better? Some people are saying not a lot. Some people are saying yes. I think this is as good as it gets. Okay, so listen up. So by way of background, where I wanted to start with the American Revolution. Because one of the principal causes of the American Revolution was that the revolutionaries vehemently objected to the agents of the king, the government at the time, using general warrants to search their desks for seditious literature, which a lot of them had because they were revolutionaries, and to search their basements for undocumented barrels of rum or tea because they disagreed with the tax law. They thought they were really unfair. So because they took very personally the idea that, this is a quote from Robert Jackson, who always had good things to say, because uncontrolled search and seizure is one of the first and most effective weapons in the arsenal of every arbitrary government, isn't that good? They provided in the Fourth Amendment that we have a right to be free from unreasonable searches and seizures. And their answer to the question of who watches the watchers was the courts. Once they wrote the Fourth Amendment and they have procedural prerequisites to searching, things like you need probable cause and a specific warrant here from a neutral magistrate, the courts were in charge of implementing the Fourth Amendment. So, problem solved? Well, the world has moved on quite a bit since the 18th century, in part because of advances in technology that make it all too easy for the government to acquire information about us outside of that Fourth Amendment framework. For one thing, according to Supreme Court case law, the Fourth Amendment almost never applies when government agents, and we're talking here about federal, state, or local agents enforcing criminal law, immigration law, family law, whatever kind of law, they can acquire information from third parties. That means our banks, our telephone companies, medical providers, maybe our internet service providers. And as the panelists, yeah?
Sorry, Susan, you're not coming in as clearly on that mic.
What, switch mics again?
Switch it out.
Okay.
Let's see it.
How's that? Is that better? Yeah. Okay, I'm not going to start from the beginning, but I am going to tell you that that the Fourth Amendment thinks that this is a pretty important issue, but the Fourth Amendment doesn't cover everything. It doesn't cover all the information that third parties hold, according to the Supreme Court. And therefore, as the panelists are going to explain, if Google and Apple are collecting information about you, and how often do they do that? Right, all the time. So it's only one very short and easy step from what Google and Apple know about you to what the government can get a hold of. Either they can just get it from the third-party custodians without even bothering with a court, or they can buy it from data brokers, right? There are just a lot of ways that they can get information that the Fourth Amendment just is not considered to apply to at all, which means we're at the mercy of statutes, and the panelists will talk about how good a solution that is. The second major exception to the Fourth Amendment, in a way, is that the Supreme Court has said that the Fourth Amendment doesn't apply to anything that you expose to the public. So that means that what you do in your backyard, where you go, where you walk, what you're doing in public, the government can send over the drones. They can do whatever they want to collect information. They can have surveillance cameras to monitor what you're doing, whether you go to a demonstration, where you're going, what you're doing in your backyard. Again, almost always without any need to check in with the court. They can use facial recognition software, license plate readers to pierce our anonymity anytime we go outside. Again, totally outside the Fourth Amendment. Okay, so if Google knows everything about us, and it's only one step from Google to the government's data banks, how many of you would agree with the hypothesis that privacy is dead and we just have to get over it? Okay, some. How many of you would agree with the hypothesis that there is no reason for me to care what the government knows about me if I'm not doing anything wrong? Okay, good. I see the heads shaking no. Okay, so you are the people who are not resigned to a total loss of privacy and care about this, and that's why you're here tonight, and that's why these panelists are here tonight, because they have a lot to say about what is wrong with all this collection of information, and about what we might do about the inadequacy of current constitutional and statutory law to control the watchers, to watch the watchers, and what we might do about it. So now I'm going to turn over the microphone, as it were, and I'll give you this one, if you like, to Austin.
So this is where having a theater degree comes in handy. Hello, everybody. My name is Austin Fisher. I am co-chair of the National Lawyers Guild here at Brooklyn Law School, class of 2024. Cool. Thank you. Thank you. And I would just like all of our wonderful panelists to introduce themselves. We're going to start on this end of the table, on the opposite end of the table. Mark, would you get us started, please?
Sure. Hi, everybody. Can everybody hear me okay? Fantastic. My name is Mark Pockwitz. I'm an adjunct professor of clinical law here at Brooklyn Law School. I'm also an associate at Ornstein Legal Group, and I am in my individual capacity here, not speaking on behalf of the firm or the law school. But I also spent several years in Washington, D.C. in a variety of roles working on federal legislative and administrative policy issues, mostly around technology, privacy, and digital civil liberties.
One more thing, could you add your pronouns after your name?
Yes, he, him.
Thank you.
Thank you.
Hi, I'm Sarah Lambden, she, her. I'm a professor of law at CUNY School of Law. I see Franklin back there. Hey, fellow CUNYite. And I got into talking and thinking about this by way of data brokers because I'm also a law librarian who uses Lexis and Westlaw a lot. And I learned in 2017 through a news article that Lexis and Westlaw, their parent companies, were also some of the government's biggest personal data brokers. And I became fixated on this topic, and I wrote a book that just came out called Data Cartels, about all the things we're going to be talking about tonight, about data brokering, surveillance, what that means for the Fourth Amendment and third-party doctrine.
I'm David Sippert, they, them pronouns. I'm also an adjunct clinical professor at NYU Law School, where I teach a state legislative externship, but I'm here, I think, most primarily in my capacity as the legal director of the Surveillance Technology Oversight Project. This is a relatively small nonprofit advocacy organization that works on issues of surveillance technology. We oppose especially government surveillance, especially discriminatory government surveillance. We work on legislation, impact litigation, and research reports. So it's sort of a multi-front attack on the onslaught of surveillance that we all face.
Hi, everyone. I'm now a little bit nervous about the microphone. But I'm sure you can all hear me okay. Okay. So I'm Lisa Washington, she, her. I am an assistant professor here at Brooklyn Law. I teach evidence and criminal procedure with a focus on the Fourth Amendment. I see some of my students here, which I'm really happy about. I guess what's important to sort of note as context, I was a public defender for almost 5 years before I went back into academia. I had some experience in another country for a while doing some comparative criminal procedure work. And so I come at this sort of with a perspective that is mostly focused on marginalized folks. I think a lot about how all of this impacts people who have traditionally had little to no privacy. And I'm excited to talk about those points with you all today.
Last but not least, how are you?
I think you already know me. Hi, Susan Herman. I also teach about the Fourth Amendment and constitutional law. And my other data point maybe is that I wrote a book about all the changes in law after 9/11, which is called Taking Liberties. And it was all about all the ways in which Congress adapted statutory law to allow more surveillance, massive surveillance, in the quote, war on terror.
Great. So I think I will ask the first question here. And the first question is just about harm. I know we talked about I guess the first question is, why should we care about this? Right? What are some examples of the consequences of massive surveillance? And anyone who wants to get us started, go ahead. Well, I guess I can start with two broad categories of harm. There's a lot of categories of harm, but one is, I do think that the extent of mass surveillance takes a psychological toll at the point that people have every move monitored by cameras, everything that they do online can be tracked. We, in fact, do see people break, and we see really serious mental health consequences. This can it can just be anxiety that we see as a quite common thing, or we can see really serious mental health crises that come from people who have internalized the levels of surveillance that are going on. But beyond that, there are also harms that are much more specific and direct. I think, especially recently, a lot of us are realizing that our criminal legal system doesn't always correspond with like the ethical systems we hold, and a lot of things that are criminalized are not, in fact, things that are wrong. A lot of people have woken up to this very recently with the fall of Roe v. Wade, with the criminalization of gender-affirming care. Some people woke up a little bit more with the crackdown on undocumented people by the Trump administration. Some people have been on top of this for a long time, thinking about drug users, sex workers, and the way they've been criminalized. But as surveillance becomes routine, these activities that I think a lot of us think of as perfectly ethical activities can result in criminalization. And I can give tons of examples, but we're now at the point where you can issue a geofence warrant to figure out, for example, everybody who came from Texas to an abortion clinic in New York and then went back to Texas, and just get all their names. Like, relatively trivial thing to do. And if you don't get the court to do that for you, you can buy it from a data broker. So these are concrete harms. These aren't just abstract ones.
I'll add a little bit to that. So I think, yes, sort of punishment that comes as a consequence of surveillance, deportation that comes as a consequence of surveillance. And by that, I mean sort of family separation more largely. And I'll give sort of an example that I've been thinking about, throughout my new research on the ways in which the family regulation system, or what some call the child welfare system, interacts with immigration enforcement. When I was a practicing attorney in the Bronx, what we started to see was that people were being arrested by ICE in courts, right? Including in civil courts, not just in criminal courts, that included family courts, that included housing. And some of those folks who were being arrested were there to file orders of protection because they were survivors of intimate partner violence. And because all of this information that they had filed was uploaded as part of a temporary order of protection into a state database, federal agents were able to gain access to that information, including ICE, and because they could find out when this person would come back to court, in front of which judge they would be, it was quite easy for them to locate people. And so there was an enormous amount of pushback in New York against that, a similar amount of pushback in California. But that's sort of one really concrete harm that people experienced there. And I would argue sort of forms of double abuse, right, that we were reinforced in situations like that. Another thing that I'm thinking about is, as we're sort of reckoning with mass incarceration, with efforts to decarcerate around the country, what has sort of replaced some of this has been an enormous amount of surveillance. And I guess we're going to talk a little bit more about certain misconceptions, but this idea that we can simply replace incarceration and brick and mortar jails through an enormous amount of surveillance, and that wouldn't cause harm to folks, I think is a really dangerous misconception.
I guess if I were to add anything, I would briefly also add that the way that surveillance and data is used, especially in predictive and prescriptive data analytics products, these systems tend to integrate pre-existing systemic biases, like some of the biases that Lisa's work raises around immigration status, and just racial, ethnic, and religious biases, et cetera, into these digital systems. I mean, I don't know. I feel like we're in a room where people are thinking about AI and tech and data, and we all know that these types of technologies, including predictive and prescriptive policing systems, are biased because they're made by biased people. And datification and kind of this datified surveillance, these new digital watchers are perpetuating and exponentially kind of diffusing biases into law enforcement and other systems that the government uses.
Well, further, I'd like to add that in a sort of broad constitutional context, there's the chilling effect on free speech associated with concern that things that people do or express, and things like public protest, things like voicing that a concern to your government, petitioning, might have sort of long-term ramifications for potential criminal or career prospects in many ways. Who here, we some con law students, Laird v. Tatum? Or have I flipped it, or is it Tatum v. Laird? I can never remember. I saw Professor Askin raise his hand. His father argued that case, I believe. But that case involved, I'm a little fuzzy, I don't remember the exact particulars, but I think that was the Air Force, was Army or Air Force, something that the armed forces were taking pictures of Vietnam protests. And so please correct me if I'm wrong. But part of the whole thing, though, the idea was this is a chilling effect, right? People aren't going to want to protest if they think they're going to be put on a database or put on some kind of enemies list. And what I think somewhat foolishly, the Supreme Court found that because the named plaintiffs were willing to come forward as the named plaintiffs, they weren't so concerned about having their identities be somewhat anonymous. So therefore, it was kind of a peculiar twisting of logic, if I remember the outcome correctly. There have been many cases subsequent to that on this issue of being in a public space or being seen publicly. And I know we're going to speak about the third-party document at some point. I don't want to jump ahead. So I'll just put a pin in that for now.
So you've already given some examples of how the government collects information without going through the Fourth Amendment warrant process, like your geofence warrant example. Can we dig into that a little more and talk about some of the other ways in which government gathers information? Sarah, maybe you'd like to start us off with talking about the data brokers.
Sure, yeah. So one way, this isn't the only way that government gets personal data, but one major way is by signing contracts for it from third-party vendors. There's a booming data brokering industry, a multi-billion-dollar data brokering industry that profits by collecting just tons of our data from thousands of sources and then selling that data to both government agencies and government law enforcement agencies especially, but then also other institutions that make big decisions about our lives, like insurance companies, banking companies, financial industry, institutions, et cetera, and also child welfare systems as well to make decisions about when to intervene in family life. And these data brokers come in all shapes and sizes. The two that I focus on are some of the government's biggest data brokers, Rita Elsevier, LexisNexis, and Thomson Reuters. And they're both similar in that they get data from over 10,000 disparate sources. They don't reveal what any of those sources are. They just say they're a blend of public and private data sources. But from their advertising material, we can extrapolate that they get law enforcement data, all sorts of public records from governments, agencies like DMVs, and voter rolls, all sorts of other public data that can be bought. And they also get data from private entities, including social media and other kind of entities that we read about a lot in the news as entities that are siphoning and sucking up our personal data. So they collect data from over 10,000 sources, and they have over 283 million data dossiers. They have data dossiers for probably everyone in this room. And the data dossiers range from like 40 to 200 pages in length. And they're also, and they don't vet our personal data at all. So the data is erroneous. And if you have a similar name to somebody else, your data is likely kind of mixed in with their data. People have found that their data is interspersed with their siblings' data and their other family members' data. So they sell these gigantic data dossiers to the government, but then the government runs those through other products like Palantir and other systems. Palantir is a Peter Thiel creation that does, among other things, predictive policing, data analytics. And then the companies also build their own data analytics systems to quickly sift through our personal data to kind of drop heat lists of who should be surveilled, of who needs intervention, of who poses the biggest risk. They can locate you and your associates on maps with license plate readers and other geographical data, and they also have a lot of your bio data, so they can make all sorts of predictions about healthcare, about maybe whether you have sought some sort of reproductive or gender affirming care, and they sell all of their services to the government in software as a service format, and the government just subscribes to it.
Would anyone else like to speak to that? David, you were mentioning the geofence warrants that could tell whether somebody went to New York and got an abortion. There are a lot of other ways that people have been worrying about Texas might be able to find out who's had an abortion or who's provided an abortion. Do you want to speak to that at all? And the electronic trails that people leave that they don't realize?
Yeah, I mean, it's almost hard to know where to begin, though I think beginning with data brokers is a really good place to begin, because whatever you can't get via the courts, usually there's a way to buy it. And it's usually very cheap. If you know a person or a combined set of data, it's really not expensive to buy. But the Fourth Amendment has now been shot through so many holes that it's quite easy to get data even without a budget. I think a lot of you might know about the third-party doctrine, which is as soon as a third party has access to a piece of information, you no longer have an expectation of privacy in it. Getting that data is no longer counts as a search. You no longer need probable cause. You no longer need a warrant, which obviously, when interacting with the way electronic systems work, is a nightmare, because everything goes through countless intermediaries. And so your trail is left in so many different places, and there's no requirement by and large for the government to go to a court, provide evidence that searching this individual person will within a particularized way, there's probable cause to believe that will turn evidence to the crime. So with, for example, a geofence warrant, they say, okay, well, if we search Google, that might turn up evidence of a crime. But that's sort of like saying, oh, we know a crime happened in this neighborhood, so we'll search everyone's house in this neighborhood, and we'll see there'll probably be evidence of a crime in someone's house. But because the way the Fourth Amendment is currently being interpreted, the government's able to do things like that. And I'll also add another source of data that law enforcement can get is directly from the government. So if you're applying for benefits, if you interact with the government in any particular way, there's rarely any sort of firewall between that information and law enforcement. And so, first of all, that's a big source of data for law enforcement, and it's also a way to discourage people from seeking the benefits to which they're entitled. Undocumented people, I think, in a very well-known way, are discouraged from seeking resources that they are entitled to simply because they're worried about information is getting turned over to law enforcement. STOP does have a bill specifically targeting this in New York that would create some level of firewall for people's personal information from one government entity to law enforcement, requiring a warrant for law enforcement to access information held by other parts of government. But that's one drop in the bucket when law enforcement has access to so much information in so many different ways.
And just to add sort of one thing into what you said there at the end, I'm thinking about how public hospitals gather information, how they conduct drug tests of pregnant people without their consent, and then transfer the information that they've gathered into typically the family regulation system. And so these systems trade information, whether that is the family regulation system / child welfare, immigration, or the criminal legal system. All of this information gets sort of transferred into different systems. And it's particularly problematic when it's being produced in systems where there are little to no legal protections, but I know we're going to get to sort of the law on this in a bit.
I think that's a great transition to the next question, which is, are current statutory and constitutional limitations on surveillance adequate? I think we've kind of already addressed that, but if anyone wants to speak on that more.
Well, I think I'll start by revisiting something that David said, which is this third-party doctrine is something that I don't think gets enough focus. And just to emphasize this, there were a couple of Supreme Court cases in the 1970s, one involving a bank deposit, bank record, and another involving something called a pen register device, which is a dialed number recorder. Has anyone seen The Wire? That TV show, The Wire? I don't want to spoil anything, but it involves this dialed number recorder to see the numbers that someone's contacting. So this 1979 case, Smith v. Maryland, involved the police putting dialed number reports against the phone company on a lot of people, and they found that one of the people matched the criteria they were looking for as to whom that person was contacting, and used that as the basis to end up, doing a search. And the question, largely, I'm going to summarize it, simplifying, was, did they need a warrant, the police that is, in order to do this? Well, in 1979, landline telephones, right? Not too many people. You had to dial the numbers manually, right? You didn't just look through your phone and look at the person's names. And so the idea here was that the police said, well, the court ended up finding that tolling records are maintained by the phone companies. There are regulations that say you must do this. You get a phone bill, the person you're calling typically knows you're calling, as does the phone company. The 3 people are involved, 3 parties, third-party doctor. That had been broadly interpreted in subsequent cases to say that really anything that you turn over to a third party loses that Fourth Amendment expectation of privacy. That means in many instances, government agencies do not need to go before an Article 3 court to articulate reasonable suspicion in order to have that information turned over to them. So there was one case that I was working on. We filed cert. The Supreme Court denied cert. But the case was involved a guy in Washington, D.C. The local tax and revenue authority issued 26 administrative laws that I going before a judge, producing over 5,000 pages of documents. And they did not rebut our assertion that fewer than 3% of those documents were germane to the case. This is the extent to which this third-party doctrine affects us. So it can affect our emails under something, the Electronic Communications Privacy Act, as part of the Federal Communications Act of 1986. Right? You have this third-party doctrine. There's the Communications Assistance to Law Enforcement Act, or CALEA, which is somewhat separate, which makes things that phones be tap-ready. And there's no necessity for the agencies to even alert you that you have been subject to this. I won't get into some of the post 9/11 stuff with national security letters and others, but the movement has been to increasing this ability to surveil, to increasing the government's ability to get information without notifying us or without going before a court. And so all of the things that we do, all of the cell towers we're pinging off of in many ways, putting Carpenter aside for a moment, the email that we send, the sites that we visit, our electronic purchases, which we'll get into in a time with COVID when people weren't accepting cash. You know, the ride sharing that you're doing, all of these things could easily be subject to a government investigation without having to go before a judge. And to me, that's terrifying.
And it's even more terrifying when you think about data brokers, which ostensibly, and the way they're treated by the courts and government agencies, is that all of that data is third-party data, right? It's owned by the data brokers. And so data brokers have thousands and thousands of your data points all aggregated together. And that is all not subject to the Fourth Amendment. So if you subscribe to a LexisNexis risk assessment service, that none of that data has been vetted or assessed or assessed for particular people. And that's why it's nicknamed Dragnet surveillance, right? Because they just take all of our data, sift through all of it on these platforms, and try to find people who they think might be committing some sort of a crime.
So I'm sort of thinking about this question in the context of state courts and practicing in state court. And I'm thinking about how to sort of carefully answer the question whether or not sort of the protections we have, whether statutory or constitutional, that exist there are sufficient. And I think it sort of almost assumes that the Fourth Amendment, for example, applies in, for example, the child welfare context, where you would think that if a state agent comes to your home, whether that's the police or whether that's a different kind of state agent with the power to remove your children, with the power to search through your closets, enter your bedroom, and all those things that the Fourth Amendment would apply. There's actually a big debate about whether or not that's the case. There's a really great new article in the California Law Review by Tariq Ismail, who's at CUNY. And so he addresses that question and very much pushes for that. But as practice stands now in New York, that is still very much a fight that lawyers are having. We have traditionally looked at sort of those kinds of protections more through the due process lens and less so through the Fourth Amendment, because we had not been successful doing so. And then there's a whole other issue of, even if the Fourth Amendment would apply, can we actually exclude any of this information that's being gathered in family court? And the answer to that seems to be no.
And then I guess one thing that I've been thinking about on a much sort of a high level is, as lawyers, we like these bright line rules, and the Supreme Court will adopt these bright line rules in one set of facts and in one way the world looks. And things that look like just a matter of degree can turn into something that sort of makes a mockery of that bright line rule down the line as technology change. So one example is the availability of data and the third party doctrine, where, you know, the idea of the third party doctrine is like, okay, you tell something to your friends, you no longer have a reasonable expectation of privacy in that because you've told someone that. But when you're trying to engage in a privileged communication over an electronic medium and you have no choice but to use a vendor intermediary, whether that be the maker of your phone or the ISP, it's a very different world in terms of what that third party looks like. And something that might look like a matter of degree, how many people find out about this as intermediaries, all of a sudden is it just a category in the world. Another is cameras, right? If you are in a public space and what you do in a public space is generally considered not to be private, that's one thing if you're worried about, like, oh, maybe your neighbor's looking out the window or something like that. But it's another thing if the city is encompassed in 24-hour cameras all the time, pointed in every single direction. And it's another thing on top of that, if those cameras are then equipped with facial recognition technology that can then sort through that data quickly and easily so they know exactly who is where and at what times, right? And so all that, it sort of feels like a matter of degree from the perspective of the way the law has evolved. But it sort of makes a mockery of that idea that this is the same world that we're living in. These are the same rule applies in both the circumstances. So I think it's sort of like a danger of an inflexible way of creating Supreme Court precedent on the Constitution when you say, okay, here's what our world looks like. We're creating this firm rule, and then not acknowledging how the world shifts from under you and the justification for that.
Yeah, I think the Supreme Court has lately been struggling with that a little. They've had a couple of recent cases about location tracking, where they've kind of recognized that they can't really apply all the old rules because there are new opportunities to get information in all these vast ways. So, you know, they're thinking about it. But I was thinking, Mark was talking about the cases in which the Supreme Court said, for example, that government can get whatever information they can from your telephone company because you've shared the telephone numbers with them. So the Fourth Amendment there, as in many other places, is missing in action. You just can't make a Fourth Amendment claim. So as Mark was mentioning, Congress decided to do better by passing the Electronic Communications Privacy Act in 1986, which restores some of what would have been the Fourth Amendment protections had the Fourth Amendment applied. You need a little involvement by the courts. However, the Electronic Communications Privacy Act has not been amended since 1986. Has anything happened in electronic communications? So we've talked about, certainly, I think we're all agreed that the constitutional doctrine is inadequate. Lisa was talking about state court. The state constitutions often do better. New York is better than the Fourth Amendment average. But what should Congress be doing? Or what could the state legislatures be doing to provide the kinds of firewalls, the kind of protection that the Fourth Amendment is just missing here? What would you like to see them do to the Electronic Communications Privacy Act or whatever else? What legislation do we need?
I mean, the good news in all this, and the reason not to come away totally doom and gloom, is these are basically all solvable problems. These are policy decisions that we're making. And you may look at Congress and see how unable Congress is to do just about anything, but that's not true. We have, I will complain about it all day long about the ways it's inadequate, but we have a functional state legislature that passes laws. I call it dysfunctional in many other contexts too, but realistically, they can and do pass laws that protect privacy in various different ways. And if the political will is there, people actually care about this. Change will be made, and you can regulate what kind of data is collected. You can regulate what kind of data is stored. You can regulate what kind of data can be shared and sold. You can regulate when police have access to that data. Anytime there's been a bad Fourth Amendment decision in the Supreme Court, like you were just saying with ECPA, it's possible that the New York State legislature can pass a law that says in New York, you have a statutory right that mirrors what the Supreme Court should have held. You have a constitutional right under the Fourth Amendment. So this is not, this is all very scary because in the status quo, we've made a policy decision not to do anything about this problem. But any day, if we all decide collectively, this is a real problem, we should do something, the legislature's in Albany right now, they can tomorrow pass a law that changes this. STOP has a package of 10 different anti-surveillance bills that we think would make a really big difference. One bill would ban geofence warrants, which I was talking about at the beginning. Another would create this this sort of data firewall between government data and the police. There's plenty, I can go on and on about the bills that we have. You can also imagine omnibus bills correcting all the problems with the Fourth Amendment that we've been talking about. It's a matter of political will at this point.
I want to point out too that what we're seeing in other jurisdictions, right? Who here has heard of the GDPR, the General Data Protection? Seeing hands going out to GDPR. Those of us who remember in around May 24th of 2018, we started getting all kinds of emails about privacy policies changing. This is because of a sweeping European-wide data privacy law passed largely in response to the Edward Snowden revelations in many ways. And so you start to see from a commercial contracting perspective, companies throwing words in paper and complying with certain types of privacy when it comes to business, but also restrictions on government. You saw California pass a GDPR style law and some other things. You've seen laws passed in Virginia, in Connecticut, involving commercial data privacy perspectives. My fear is that from a patchwork of data privacy laws in various states, who here knows Wickard v. Filbert? One of the cases I hate the most. The idea that it gives the federal government broad power under the Commerce Clause to regulate nearly everything, including illicit marijuana growth. Anyone remember the case? Gonzalez v. Ray, that's exactly. Wonderful. Very engaged on it. So no, but part of the idea too, though, is that no matter what we do with the states, and hopefully we do get to be passed at the state level, because it could be some kind of wake-up call to have the federal government try to come in preemption, depending on how it goes and how it's architected. But I do think that we saw following the Snowden revelations, those of us who were in DC who were involved in the time, we thought that's when we get something done. And so it's interesting to see what the triggers are for people to be concerned about different kinds of things. And perhaps some of the recent Supreme Court cases and the sort of potential knock-on effects and great horribles may convince people that now would be the time to take stronger action.
Great. I think the next question is, what are some common misconceptions about surveillance and the law relating to it? Some things that maybe we do every day, maybe some things that people don't think about when we're using technology that are particularly upsetting.
One of my favorites, because my students say it all the time after we have an especially creepy data privacy class, is the claim that your phone is listening to you. And the reason I like to kind of hit at that fallacy is because I think that the reality is creepier. So it's not it's not that your phone is listening to you, it's that your phone has collected so much data about you and where you're located and the people around you, that if you are standing next to your friend and you are both at a coffee shop, your like little data cloud is combining with the person next to you's data cloud, and they know exactly where you are, so they might start marketing the same thing to both of you, right? You might start getting targeted ads because your friend has been looking at vacation destinations that happen to be the same as yours. There was this interesting story that somebody told, I forget in what forum, but they went to their grandmother's house and they suddenly started getting all these ads for a certain type of toothpaste. I think that works well for like dentures. And he couldn't figure, he was like, how am I getting it? And then he started kind of deducing, like looking back, like his grandmother uses her iPad and plays Words with Friends on it or something like that, right? And then she buys her toothpaste on Amazon. And so that, like, just seeing kind of the generation of data that led to that kind of advertising targeted at him, because it's much more than, it would be great if the phone was just listening to you and that was the only data source that they had, but it's not.
I guess mine is not really a common misperception, although that just scared me a little bit too. Yeah, very interesting ads that I get. So the thing that I sort of led with earlier was, I don't know that this is a common misperception, but I think this is sort of a common trend that I think is pretty dangerous. And that's sort of this idea that we can get ourselves out of mass incarceration and we can decarcerate through means of extensive surveillance. And I mean, not only incarceration through the criminal legal system, but also through the immigration system and immigration detention. And we've seen from ankle monitors to all kinds of other mechanisms by which state agents monitor the every move of someone and how that impacts sort of the world around them, their family in particular. There's great literature on this by Kate Weisberg, who's written about this, but there's more and more. And I think there's sort of this danger that we use surveillance for certain people to replace incarceration in sort of in an effort to limit some of the harms that mass incarceration has caused. And I think that's a really dangerous trend.
I've actually heard people say on that subject that what was good about after 9/11 was that nobody was locking up all the Muslims because, in fact, you could keep an eye on everybody all the time, and it was so much better than what had happened during World War II. And you have to think, wait a minute. Did go
I was
ahead.
just going to give one more specific example of misconception. It's based on something that Lisa mentioned earlier with healthcare records, which is I think the one thing that people think that their data is private is healthcare, but that's not really true. Like HIPAA everyone's familiar with HIPAA, but it's actually a relatively specific statute, and it applies only to a certain class of entities carrying a certain class of data as part of their business. Relatively narrow. Most of the healthcare information that you transmit is probably not protected by HIPAA. Right now, I gave you it's possible to fix it, but right now our state of our laws is really bad, even in the places that we think it's not so bad.
One other thing I'll mention there is that because the Fourth Amendment is absent, if Congress protects privacy in a statute like HIPAA or the Electronic Communications Privacy Act, they can then make exceptions to that statute whenever they feel like it. And that was the Patriot Act. They could make all these exceptions because it wasn't the Fourth Amendment that they were touching, it was their own previous statutes. So that's how the bar gets really lowered. So we've been talking a lot about how you could control government collecting surveillance or use of surveillance through law. What about what we do? Okay, how many people in this room are really careful about the privacy settings on your phone? The front row, isn't that interesting? It's the front row, the eager beavers here. Okay, so what would you say to people in terms of self-help? What should be people be thinking about and doing in terms of protecting our own privacy? Read that one.
We used to talk about this concept of internet hygiene, but it didn't really ring well, resonate with audiences. And a lot of people didn't really understand the extent to which this information can be collected. For those of us familiar with the Katz decision in 1967 know that it's the Harlan Curve that uses the phrase reasonable expectation of privacy. But the majority was taking steps to secure your privacy. Now, from a normative perspective, reasonable expectation seems to be what people tend to focus on. So there's a lot of questions out there. So if somebody does use encryption when they send emails, is that them signaling that they think the communication is more private? Or does that also signal if you don't use encryption and you're okay with your communications being surveilled? From a technological perspective, we all know that our phones collect a lot of information about us. Some of us have downloaded third-party keyboards that do fun GIFs or emoji. Do you read the terms of service? Who here has ever read the terms of service for these applications?
The front row again.
But you realize that some of them do keystroke logging. So anything you type can be collected by these companies, and your experience can be shared across devices if you want to synchronize that between your iPhone and your iPad, or your Android phone and your tablet. So it's very difficult. It's almost a full-time job to read all of these things, which grow increasingly in length, and to have a sophistication to understand what this thing is doing all the time makes it very, very, very hard. So yeah, I don't know if there's maybe BLS should offer a class on protecting your information. And certainly there's a change to the New York State bar rules regarding cybersecurity, because a lot of people aren't fully aware of the risk. So it's very hard. I did some work when I was in DC. I needed to have an air-gapped computer. Who knows what that is? It's a computer that wasn't connected to the internet and lacked inside the physical hardware even to be able to connect to the internet. It did not have I had to build it. It didn't have a Wi-Fi card, and it didn't have a network interface card, a NIC, to be able to connect it. And I needed to follow strict protocol where I was sent physical DVDs or CDs that were burned, and I was not able to plug anything into the computer that could exfiltrate data. So no thumb drives right near the hard drives, only read-only media to connect to it, because of some of the work that I was doing and some of the clients that we have. And it's very onerous and very challenging.
I'll just say, a lot of this stuff is like not practical for people to do, right? So the number one thing I'd say is like, let's change the laws, because you absolutely can make a law that says it's not legal to store keystrokes, like, period. You could say that if you want. But if you do the sort of easier things, like at a time when you're doing something you don't want people to know about, like turn off your phone, pay in cash, and like don't exchange unencrypted electronic communication of any sort. Like that's like bare minimum if you're doing something specifically you don't want people to know about. But other than that, like by and large, I think we really just need to change them.
I agree. And I would say, so in my book, I say some pretty negative things about the idea of data hygiene, because I've come to see the idea of data hygiene as kind of a PR campaign by tech companies in the same way that plastic recycling campaigns were kind of greenwashing by fossil fuel and plastic industries. I think it's a really fun way to put the onus of data privacy on us instead of putting the responsibility on the companies and entities, government entities that are taking away our privacy. So I agree, we need laws because it is so onerous and it is so difficult in this day and age to protect our own data privacy because these companies and government surveillance and everything is so invasive. So yeah, it shouldn't be on our shoulders to be like very, very hygienic when we use these products. It's on the product manufacturers to make better products for us.
So Ruha Benjamin's work has really been helpful for me in this context, and she sort of gives a couple of examples to sort of show, is there a world where we could protect any of this information? And so basically they do a study and follow sort of the life of a woman who tries to be very intentional about the information that she shares. So she does those things, she uses cash, she uses gift certificates, and it gets to the point that people become suspicious of her, right? Because there is no trail and because she's constantly using these gift certificates and cash. And so that sort of turns into a whole other thing where perhaps the government, when she does have system contact, becomes suspicious that her trail looks so different from everyone else. So that's sort of not a very positive note on this. I think I can't give advice about privacy settings and stuff like that because I'm very bad at it. But I am very careful about what providers I interact with. And I think that comes from my experience representing people who've had contact with certain providers. And I recognize that's sort of a luxury to have if you have it, to be able to choose your providers, right? But if I were to choose certain hospitals to go to in New York, they would probably be on the Upper West Side and they would probably not be in the South Bronx, right? Because I feel that my information might not so readily be shared with state agents in that context. But that, again, is not something that everyone can incorporate into their life.
One more thing I'm feeling compelled to add, because I feel like I talk about abortion most of my life these days. But you all know that there are all sorts of ways that, as we were saying before, the government can find out things. And it's not only the geofence warrants, it's all sorts of other things that people actually could control if they were really, really determined to. So did you hear about the mother and daughter in Nebraska who ended up being in trouble because what they posted on a Facebook page, and that information ended up in the wrong hands? Did you hear about the guy in Texas who is suing the friends of his, I think she's now the ex-wife. She was certainly suing for divorce because she decided that she wanted to have an abortion and texted her friends to say, help. And one of them said, here's how you can get the abortion pills. You can come do it at my house. And those texts ended up, because of the husband, not the government, he takes the screenshots and whatever, and those texts end up being the basis for a wrongful death lawsuit that he's now bringing against the friends of his wife for aiding and abetting this abortion. So all this is pretty terrifying. And on the one hand, the Digital Defense Fund, if you're interested, has some great pages on all the things you can do. Use DuckDuckGo, don't use Google. All the things that you can do to try to avoid leaving an electronic trail. But where I end up is, as you were saying before, it's just being infuriating that a woman in this situation should have to think about this at your most vulnerable point. You're thinking, how do I avoid leaving an electronic trail? I can't text my friends. So as you're saying, we desperately, in light of Dobbs, we need better data protection because there are all these states that are going to be after this information from around the country as well as within their state. So I think we rather desperately need for Congress isn't going to do it anytime soon, but for a whole bunch of states to be protecting data that we are collecting or exporting.
I think with that, the next question is kind of about another thing that has kind of recently happened to all of us, which is COVID. How has COVID kind of accelerated this or affected the landscape of surveillance? And I saw you nod your head, Mark, so we'll start with you.
Well, I lived in the UK when COVID sort of broke out, and in London, and I was living in Belfast in Northern Ireland, which were heavily surveilled places. And so we were doing a lot of thinking about what this meant, and the idea of contact tracing was something we were very concerned with, not just manual contact tracing, but the idea of proximity contact tracing using applications on smartphones. The idea that a lot of places you had to pay with a credit card or a debit card instead of cash. And the idea that certain jurisdictions were having such severe lockdown, there was a concern whether or not your phone would betray that you were violating some kind of lockdown or rule. Now, I'm not going to get into the public safety aspect and what we knew as a society with respect to the risks associated with COVID at the time, but the idea that a lot of people seemed very willing to engage in sort of this system wherein we were sharing all kinds of information, whether the app was a government app in some places, a municipal app in some places, or other information about where we had been at different points in time, was sort of odd to me. Having been somebody who worked in privacy and tech policy issues in a post 9/11 Washington, D.C., and the concerns we have there, when the fact pattern was slightly shifted, a lot of people didn't really stop and think about what the long-term ramifications could be. I always like to point out that the U.S. Department of Agriculture, anybody know when the USDA started? Who was president? Yeah, Abraham Lincoln was the president when the U.S. Department of Agriculture was started. So it goes back very far, and its purpose wasn't the same as it is now. I bring this up to say that when government does get authority and power to do something, it doesn't like to give it away. So with respect to the idea of the types of things that we saw people willing to engage in in a time of COVID, I was very concerned about the long-term ramifications of surveillance. And I'm sort of glad to see that it hasn't stayed that way. But I think we've yet to see what might happen. Sorry, I'll get on my soapbox.
Maybe for our last question before we go to Q&A, our last question to the panelists. So one thing that we were saying, David, you were saying that the legislatures could be doing something about this. They just aren't. So it seems to me that one reason that why they're not acting is that they're not hearing a lot from their constituents. Nobody's lighting a fire under them. So what could lawyers and law students be doing in the interest of getting better legislation and better limits on all this surveillance?
I'm a huge proponent of law students being involved in the local political process. I think that we, in the legal academia, are so focused on the federal system, on federal courts, and we barely even focus on federal legislation by and large, because that's considered like below the legal academia, much less looking at what's going on in the states. And when Congress is completely deadlocked, like it's been for a very long time now, and the states have plenary power. The states are really where the action is in terms of legislation, even when Congress is functional. The fact that we, as lawyers by and large, ignore what's going on in the states, I think is extremely detrimental to the ability to make progress on just about any issue, but especially on an issue like this, where it's a grind.
I think we could also use more tech-savvy lawmakers and policymakers. This isn't an ageist comment because any aged person can be technologically savvy, but I will say that right now in a lot of our government, our lawmaking bodies, there is a lack of technological savvy. So if any of you all are interested in bringing your tech savvy into kind of thinking about these problems, I think that's really helpful. And that's something I always tell my law students. So all of you law students, take your tech savvy and your personal experience growing up in a world that is full of the internet and that where you have used a lot of these tools, and take that to Congress or to whatever lawmaking body and tell them what you want.
All right. I think with that, let's go to Q&A.
Katie over here is going to be running a microphone if y'all have questions.
And can you say your name before you comment your question?
Yes, name and pronouns.
Not that we
please.
don't know you.
Hi, everyone. Can you hear me? My name's Anjani. My pronouns are she, her. Thank you so much for being here and for this conversation today. We talked a little bit about misconceptions when it comes to surveillance, and we also talked a lot about post 9/11. I was wondering if you could talk about the misconception between surveillance and national security, and as it relates to all of your relevant expertises. Thank you.
Well, I guess I'll open up and keep my comments brief in that, oh gosh, I don't know if I can. No, but the way the U.S. intelligence apparatus sort of came up from immediately before World War II when it started in July 1941, I'm going back way too far. The United States has always focused on signals intelligence rather than human intelligence in a lot of ways. So what that translates to is a lot of the sort of national security apparatus ingesting large amounts of data and trying to analyze it to find things. A lot of our perceived enemies following World War II were closed societies where we couldn't really get human assets in. So the focus became on code breaking, intercepting radio transmissions, that sort of thing. So particularly in the United States, our presumption is the more information we have, the better, because we're very good at using deductive reasoning to track known threats rather than inductive reasoning to identify potential threats. So at least in the United States, there is this idea that surveillance is incredibly important from a national security perspective. In places like Germany, which has a terrible history with the Nazis and the Stasi, you saw a huge outrage following those disclosures because they had a better understanding of what the risks could be to people. But I'll cut myself off there if I go on for hours.
I would say quickly, less on national security because we're so focused in New York, but just on public safety issues. A lot of these surveillance technologies do not work the way they're advertised. And if our state and local governments really hit any spine, they could very easily sue the manufacturers of these technologies for all sorts of false and misleading ways in which they're advertising these technologies, often to the governments in order to get big contractual purchases. If you look at ShotSpotter, the automated gunfire detection software, I don't have the number, so I won't say it, but the vast majority of gunfire shots detected are false alarms. If you look at facial recognition, they give numbers like, oh, it's 95% accurate, but that's like for middle-aged white men under ideal lighting conditions. As soon as you deviate from that, the percentage is lower. In real-life situations, is often over 20% error rates, and that is not evenly distributed across race. For Black people, for Asian people, for gender non-conforming people, you will find substantially higher error rates. By some metrics, a Black woman might be 100 times more likely to hit a mismatch than a white man. And so, we are seeing false arrest, mistaken arrests on the basis of this. So these are expensive technologies. That money could absolutely be used in ways that are better at providing safety, for example, providing resources to these communities as opposed to over-surveilling them.
Sorry, I'll just add a headline to what David just said and underscore it. We will not be able to surveil our way into public safety. I think that's a really important point and underscore everything that you just said.
And for being here. Ooh, and this is a fun mic. I guess I'm wondering because I think that I agree that the gain really for moving the ball forward on controlling some of the surveillance apparatus is at the state and local level. And at the same time, the federal government is making it really appealing for state and local agencies to get access to budget dollars to buy ShotSpotter, to buy these different things. So the feds are opening up the coffers, the states need the money for all sorts of things. And so I'm wondering, how do we deal with this interest convergence piece?
It's really tough, because kind of the tentacles of these private surveillance industries are so deep into the government. I feel like that, that's one of the rationales I give for why we don't have more robust kind of third-party surveillance legal legislative action is just because the industry has kind of captured our law enforcement agencies. So yeah, I think it's a problem of agency capture, and I'm not sure how to resolve it.
Or just, you can just cut government budget a lot.
Yeah, there you go.
Really, I mean, in Washington, you see this whenever the fiscal year is ending, Q4, all these organizations are buying things and issuing grants like crazy because they don't want to give money back. The budgets are tied to prestige. And if they are able to spend all of their budget, they can go to the next appropriation cycle, the Congress hat in hand, saying, we spent the $1.7 billion you gave us, now we need $2.1 billion. There's a perverse incentive in a lot of federal agencies. I don't really do state policy work, so I'll defer to David on this. I don't really know how it works. I was a federal policy. But largely speaking, what I would often witness is they have the money to want to buy something cool. And we saw this post 9/11 with all this excess of military equipment, where we had this militarization of police with a lot of folks coming back from overseas with the military experience and a lot of the excess military equipment and manufacturing capacity. And before I stop talking, the farewell address by Eisenhower, where he coined the military-industrial complex, the initial drafts of the speech, does anybody know what they said? The military-industrial congressional complex. And I think that it was a very prescient observation as it is today.
Following up on the point that Lisa was making, that you can't really, surveil your way out of this. I had occasion to speak to Thomas Drake and some of those other NSA whistleblowers who basically said the government was drowning in data after the Patriot Act and all. They just kept putting things in the data banks, and the algorithms that they thought were supposed to tell them things did not really work. Evidently, they thought they had improved the algorithms, but it's not enough to have information. You have to be able to do something productive with the information.
And mechanically, whistleblowers like Thomas Drake, Kurt Wiebe, and Bill Binney, who tried to go through the proper process of reporting this witchcraft abuse,
And the problem is that Congress has not much cared. After Edward Snowden's revelation, they had some hearings and talked a little and had some very modest improvements, which even Barack Obama was not looking for much change. But that's why the political will for more control on surveillance, I think it gets back to the misconceptions. People think that if the government has a lot of information, it will keep us safe. And what they don't get is it's not even just that it doesn't keep us safe and it's too much spying on us. But the point that we were making before about the marginalized communities, it's one thing to say, I'm willing to give up a little liberty in order to be safe. But it is a completely different thing to say, I'm willing to give up those people's liberty in order, because I think it's going to keep me safe. Go ahead and have all the Muslims under surveillance. Doesn't bother me.
And I think sort of this metaphor of the canaries in the coal mine is helpful there. Sort of to think about, as we're watching other people being impacted by that, right? This is not just other people being impacted, this is us being impacted, and those are the signs. And if we're not paying attention to that, it's going to impact us in the same ways.
And just to piggyback on that, I mean, the types of, it's sort of a then they came for me kind of idea, right? This idea that it depends who is being targeted at a given time, right? Following 9/11, a lot of people who weren't Muslim weren't as concerned. But as we see more rates shift, and a lot of the people who were being targeted then are not being targeted, let's say, the government now. So if you're somebody who doesn't think that there would be a reason for the government to target you because of your beliefs, your activism, the things that you do, recognize that, Muslims before 9/11 didn't think that they would be targets, right? So it always can depend on who or the whom broadly is sort of the focus at any moment in time.
So you're talking about others. This is making me think of a film recommendation. Has anyone seen The Lives of Others? It was around a few years ago. Great film about the Stasi and what was happening in East Germany when everybody was under surveillance all the time. And so I had occasion to do a lot of comparative, national security law and be in places like Brussels, where people from all different countries would be talking about what they were doing with their statutes to try to promote national security and what controls they were keeping on privacy and what they were willing to let go of because it was more important to be secure. And the people who were most adamant that you needed control on government surveillance were the Germans because they had been through it. Is there, Jonathan, if you don't have a question, I would love for you to talk about your student hacking the menstruation app, because I think it's such a great example. Do you mind being called on? This isn't about your own. I thought you would like to brag.
Anyone working on monthly app?
There you go. This is a great example of what law students can do, right?
I'm happy to talk about it. We're building an app. It's a period tracking app, but the important component is we're building into it a data trust so that all of the data will reside in what we think, if we build it properly, will be protected through the third-party doctrine from Fourth Amendment surveillance. We're also hoping to partner with medical providers so that we may add an extra layer of HIPAA compliance. Whether or not we will succeed in creating a data-secure repository is a little bit unclear. We're trying to work it so that the data resides at the end user, and every time someone needs to run an algorithm on the data, the end user will deliver the data so that the algorithm can process the data, and then it springs right back to the end user. So it's never belonging to a third party for any length of time. And so there's no third party out there that can actually give the data over to either another corporate entity or to the government.
Would it make sense to talk a little bit about the iPhone San Bernardino kerfuffle in 2016?
Why not?
Is anybody familiar with this? Does anybody want to jump in and give a background on it? There was a workplace shooting in December, I think it was 2015, and the shooter was a fellow called Saeed Farouk, and the question was whether or not it was terrorism related. Saeed Farouk worked for the Department of Public Health for the county of San Bernardino. And the phone, the subject device installed was an iPhone 5C. It was Farouk's work function. And following the attack, the FBI got their hands on the phone and changed the iCloud password. Remember we talked about third-party doctrine, Stored Communications Act earlier. But then the question was, well, how could the government get into the device itself? It was a passcode, and too many failed attempts to brick the device, make it unusable. And so the Department of Justice in February, I don't remember the exact date, filed a very sophisticated ex parte motion on behalf of the FBI, in which they explained very technical means by which Apple could create a custom version of their operating system to allow the government to brute force the device, right? 00000001, all the way up to 9,999. They also wanted to remove the delay between successive failed attempts. You can't immediately have a kid inadvertently do it. There's time delay. And they wanted to make it so that the FBI could remote brute force it from the crypto lab at Quantico. And so Apple was given an order. Judge Pim, the magistrate court center just California, said, this seems reasonable. Apple, you have 10 days to tell us whether or not you should be compelled to do this by the government. So this brought up something called the All Writs Act, which is part of the Judiciary Act of 1789. Which essentially says that the courts can issue any and all writs necessary and appropriate to aid within their respective jurisdictions. So the courts can't use the AWA to take jurisdiction of the thing. If something is within its jurisdiction, they can sort of do what's necessary. So it opened up this really big question as to the extent to which the government could compel third parties to do things for them. One of the presidential cases was a United States versus New York Telephone 1977 case, which is also part of that Smith v. Maryland, United States versus Miller triad of third-party doctrine cases from the 70s, in which I think it was a suspected gambling operation, and the feds tried to get the New York Telephone company to sort of pen register trap and trace devices on the phones of the suspects. And the court at that time said, well, this is something you do regularly. You're not inventing new technology. You do this all the time, so you can be compelled by the government to provide meaningful assistance, so long as it's not unduly burdensome. So this was one of the main legal issues here. Eventually, an Israeli company called Cellebrite offered the technology to be able to get into it. It's not public. They hadn't admitted it, but everyone sort of agreed that should happen. But it really opened up this question is the extent to which the government can compel third parties under an Article 3 court order to do things. And it's still largely unsettled. So whenever we think about technologies, we be able to apply that can circumvent things. The question might arise again at the extent to which a court can force a company to try to do things to help the government get more information. That also is terrifying.
Any other questions? I see one over there.
My name is Lou Schwartz. I'm a an alum and a public defender. With respect to the 24-hour camera surveillance and maybe facial recognition, in the media, the 24-hour surveillance seems to be focused on apprehending people who commit crimes. And it's not only the surveillance out on the street that's run by government, by police cameras, but merchants, store owners have them in the stores for their security. And I don't think there's too much question about the efficacy, at least for that kind of security inside a private premise. And oftentimes, when a street crime is committed, the first place that the police go to is not their government cameras, but they canvass the cameras around the area. So it's seen by the public, and perhaps correctly, as a way to safeguard the community and as a safety device. Also, it's a two-sided device in that I have had clients who ask, please get the surveillance camera, please get the store camera. Sometimes it helps, sometimes it doesn't. But it's a two-edged sword, just the way DNA is a two-edged sword. It exonerates and it convicts. So I don't think that one can make a generalized statement that it's dangerous and harmful. In terms of what we've experienced, I haven't heard too much data or information or reports about 24-hour surveillance cameras being used for untoward purposes. Comment?
So I could start on that one. So I've certainly had the experience too that sometimes the video that you find in Discovery and that you have actually turns out to be sort of helpful for your client's case, right? And so finding that information, being able to use it, being able to negotiate with it can be helpful, right, for this individual person. I think when I'm thinking about surveillance and its larger impact though, I think it connects with something that David said earlier about where we're putting the resources, right? And I think if we're making decisions about, are we going to, and this is, I think, what my comment about we can't surveil ourselves into sort of a system that is safe is about, is if we could allocate resources into that and we could surveil people more, or we could think about other ways that make people more safer, sort of on a more foundational level, on a more structural level. And so that's sort of, for me, in some ways, sort of the trade-off there.
Yeah, I think that hits the nail on the head in a lot of ways, because there's two different debates. One is, what should our laws be? And I don't think there's anyone pushing to ban stores from having regular surveillance cameras within their stores. No one has proposed that law. Now, do we generally want to live in a place that is covered with cameras or not? And you may have different answers for different people. But I think very reasonably, a lot of people, even people who are concerned with safety, would say that the answer is no, that we don't want our streets, our storefronts covered in cameras. What should policy be in response to that is an interesting question. One thing that I think we could do to start is to ban facial recognition in those cameras. Another thing we can do is limit where the cameras are, where they're pointing. For example, NYPD has pole cameras across the city. These cameras can rotate 360 and they can zoom, and absolutely they can see into people's windows if police direct them that way, if those windows are left open, for example. And that's sort of baked into the technology. Has yet to be litigated and should be. There's all sorts of ways in which cameras can be restricted versus where they currently are, and fought against, for example, required expansions of cameras. But that's very different from saying something like, and I don't think that anyone's proposing like an absolute ban on all cameras across the city, but the dialogue at least is talking about it, like, what kind of a society do we want to live in? Like, how do we want cameras to interact in that society? Like, what is the right role of them? What are the right restrictions on them? That's like a conversation that we need to be having. And I would be very surprised if many people thought the right answer was, 24-hour facial recognition surveillance on everyone at all times. But that's the direction that we're headed if we don't do something.
Well, I think the other issue about legislation about all the cameras is not just can the camera watch you, but what then happens with that record? How long is it kept? Who is it disseminated? Who is it shared with? And their legislators, I think, are somewhat more willing to think about that, controlling the use of the data.
Do you need probable cause to require someone to give that information over? Under what
Right.
circumstances are they allowed to give that information over voluntarily? Like, these, absolutely right. How long can you store it? These are all the types of questions that we should be asking and trying to find like the world that I think Lisa's. I will follow Lisa into.
The one I'm dreaming about.
Yeah, and I would, so this is kind of a conclusion point I came to after like years of researching these big data brokers. I don't think that data is inherently bad, right? The existence and collection of data and information, including like video camera information, is bad. And in some cases it can be really helpful. Like I have to say, I was grateful for knowing based on contact tracing or based on reporting where COVID, what the COVID rates were all over the country. And I am grateful for social media and other, technologies that are run on data. Like I think there are times, like I use my phone to find the directions on how to walk here. And I'm really grateful that my geolocation data tracked me as I came along my path. So I think that it all goes back to the, how we regulate data and who gets control. And I think that's really what it is. And once again, it goes back to what Lisa said, like what kind of a world, now that we have this amazing technology, what kind of a world do we want to build with it?
And with that, I think that's a perfect point to say concluding remarks. Like, do any of you have something that you want people to take away from tonight? I know it's kind of a big ask, but like, anybody have anything that they want to say to conclude?
I want everybody to know who your state and local legislators are, and I want them to know who you are because you've been so annoying about how often you've been contacting them about these and other issues. That's my ask.
I guess I'll say, because a lot of this was so depressing, I think a more interesting sort of into the future look into how some of this could look in sort of a more inclusive, interesting, forward-looking society is in some ways, I think I find that in Octavia Butler's work and her fiction, in her sci-fi, it makes me not less pessimistic about technology if I think about all the ways that it could be used in interesting, innovative ways that are a little bit detached from the status quo that we have and the structures that we're all embedded in.
And I think I would also, I want to prop up the work that Scott does and the work that Austin and David are doing and everybody who's there drafting this type of legislation, because I do think that there's a lot, there is good. I have to hope that there is good, right? And it's all about how we leverage our power as a society against the power of data brokers and government, kind of the government surveillance industry, the government surveillance industrial complex. But it's all about power. And I do think that if we draft the right types of interventions, we will be able to regain some sort of power and demand accountability.
I would say you make your voices heard, get informed. Like, you're all here. That's great.
And maybe I'll add to that where I started, which is not just get informed, but inform others. Tell them why we can't give up on privacy and tell them why, what you've learned tonight.
All right, and with that, I think Professor Godso will close us out.
Yes, so I am Cynthia Godso. I'm the current director of the SPARE program, and I understand that I'm, standing between us and food and drink. So I just wanted to take 1 minute, really here to express gratitude to so many people. But first of all, to the SPARE family and the program and Professor Schneider started. There's actually some information about the amazing history of SPARE and the program. And the fellowship program on the back of the program, if people are interested. And then also to our amazing events and support folks, Liz Alper and Marva and Chris and Michael, who just, done an amazing job. To you all in the audience for being here, to this incredible group of students, Austin, Caitlin, Jowl, Anjani, Aaron, Megan. There's also more, but just an incredible group of students who came together to plan this. And most of all to our panelists for giving us a lot to think about, maybe a little to be scared of, but also a lot to be hopeful for. So with that, let's just say thank you and we can go upstairs.